So you are now live. Okay, let me welcome you to the final of the 2020 FDI Moot between Team Verhoeven representing Claimant and Team Crawford representing Respondent. Our arbitral tribunal consists of Wendy Miles QC, Charis and Nikita Kondrashov. Wendy Miles is a specialist in international arbitration and dispute resolution with a focus on private and public international law. She's advised a wide range of multinationals, including corporates, sovereign states and state entities, and multilateral organizations. Wendy assists clients across numerous sectors, including energy and natural resources, so quite pertinent to our case today. In the field of climate change and finance, Wendy acts as a global coordinating counsel to various major corporates, and she regularly advises investors and states in respect of climate-related physical transition and litigation risk. Charis Tan is a partner at Peter & Kim in Singapore. She specializes in international commercial and investment treaty arbitration and public international law. She's admitted in Singapore, England and Wales, and New York, and her experience includes investment and commercial arbitrations under the rules of all the major institutions, including ICSID, SIC, ICC, SCC, and of course, UNCITRAL rules as are applicable in our case currently. And that experience includes work both as counsel and as an arbitrator. And last not least, we have Nikita Kondrashov, who is a partner at Urloff & Partners in Hamburg, focusing on investment and commercial arbitration, commercial and corporate disputes, and corporate insolvency. And most relevantly for us now, he is one of the authors of the case that has been enchanting and simultaneously confounding all of the 2020 FDI Moot participants, and he has been known to moonlight as Perry Mason from time to time. So with that, I will turn it over to our esteemed tribunal. Have we determined the presiding arbitrator? Charis, are you willing to do that?
No, I think Wendy just.
Wendy's doing. Excuse me. Okay.
We agree that Wendy would be
good. Okay, very good. So Wendy, with that, I will turn it over to you. Thank you.
We elected on the basis of age, Chris. Good afternoon, everybody. Welcome. Well, I hope it's afternoon or morning and not the middle of the night for anybody except our arbitrator Tan. So welcome everybody, congratulations, but welcome to this hearing, and If you could perhaps just begin, I will introduce the tribunal. If you could perhaps then introduce yourselves, starting with the claimant, Verhoeven. Each introduce yourselves and what you're going to cover, and then if the respondent could quickly introduce themselves, and then we'll get started. So Mr. Kondrashov is here and not offended by any of your challenges. Ms. Tan is the third member of the tribunal, the other co-arbitrator. So if we begin, please, with counsel for the claimants.
Thank you, Madam President. Hello, everybody. My name is Shannon Honoré, and together with my co-counsel, Ana Quartero, we represent Goliath National Bank, or GNB, the claimant in the present proceedings. To answer Madam Arbitrator's questions, the parties have agreed that the respondent will start on the issues of the challenge and the jurisdictional objection, then followed by claimant, which I will present. Leaving 1 minute for rebuttals and sur-rebuttals following these issues. Each speaker will speak for 19 minutes. And then the claimant will start on the issues of attribution and merits, and that will be my co-counsel Ana Quartero on our side, followed by the respondent on these issues, and again, leaving 1 minute for rebuttals and sur-rebuttals.
Thank you very much, Ms. Henry. And for Crawford, please.
Good morning and good afternoon and good evening to the members of the tribunal and opposing counsel. My name is Charis, and alongside my co-counsel, Mr. Italo Martins, we hereby represent the Republic of Laic, respondent in these proceedings, and we agree both with the order of the presentation and the time allocation proposed by opposing counsel.
Many thanks for confirming, Ms. Paris. I appreciate that. Ms. Henry, if you would like to proceed, do either of the arbitrators need any clarification on order?
Not for me, thank you.
Okay, excellent, thank you. Ms. Henry, you may proceed, thank you very much. Oh, I'm sorry, no, I'm sorry, I was paying attention. Ms. Paris, you may proceed.
Thank you, Madam President. Members of this tribunal, even luck may be deceived if you may roll the dice as many times as you want. And this case is precisely about that, a dice that has been rolled over and over the financing agreement, an instrument originally signed between Mercuria First National Bank, the company that provided the funds for the construction of Decadia 1, and Mountaintop, the company that provided the guarantees for that loan. Out of MFNB's exclusive dissatisfaction, the first dice was rolled, a commercial arbitration against its own business partner, Mountaintop. And before that dice had even landed, MFNB assigned its investments and attempted to assign its claims to Goliath National Bank, the claimant in these proceedings, who's now rolling another dice, both by filing an arbitration in which it has no legal standing and by appointing an arbitrator that gives rise to justifiable doubts. In order to prevent this arbitration from becoming the gambler's paradise, respondent respectfully asks this tribunal to find at first, claimant has no legal standing under these proceedings. And second, that Mr. Perry Mason should not compose this tribunal. Beginning now with my first submission, it is respondent's position that claimant has no legal standing under this arbitration as the assignment of the claims pertaining to Law 66 and the Directive 87, both from 2016, are not assignable to a new investor. And the claim and the respondent will ground its submission under one main argument, that is the time of that assignment. Members of this tribunal, it is important to take a step back and understand that the ASNEC Treaty is silent concerning the assignment of claims. Now, some treaties, such as the Energy Charter Treaty on its Article 15, provide for the subrogation of rights and obligations within the scope of the treaty itself. However, under the ASNEC Treaty, at no point we can find express considerations regarding the assignment of claims.
Also, if I may interrupt you there, is this truly an issue of subrogation or is it a issue of jurisdiction ratione temporis?
It is an issue of jurisdiction ratione temporis, Madam Arbitrator, and I'm sorry if I did not make myself clear at this point. It is the respondent's contention that merely some treaties may provide references to the assignment and also to the subrogation of rights, as it is one of the contentions here. So the silence of the ASNEC treaty, it is respondent's contention that should be interpreted as a prohibition regarding the assignment ratione temporis of the claimant. Now, members of this tribunal, although the claimant may try to allege that respondent is not in accordance with the assignability of investments in general, that is not the respondent's position. Rather, that the ratione temporis requirement of that specific assignment has not been fulfilled. Members of this tribunal, on the merits of this dispute, the claimant's counsel will allege legitimate expectations that have been broken according to its position from the time it was not an investor. In the sense, the merits of this dispute concerns legitimate expectations, or rather allegations of legitimate expectations of MFNB, the original investor. In the sense, it is the respondent's position that only the original investor may file claims pursuant to the time it was the investor. That is, Goliath National Bank was not an investor in 2016. That is because the assignment agreement was only concluded in July 2017. Considering this,
Counsel,
for instance,
I'm sorry, can I interrupt you for a second? So basically, is it your case now that the rights to bring investment treaty claims are intuitu personae, so they are not assignable per se?
No, Mr. Arbitrator, it is not the respondent's position that general assignability of claims is not possible, but rather the fact that the assignment of that particular legal claim pertains specifically to Mercuria First National Bank, as it was the investor who was protected by the treaty at the time the alleged fact, that is Law 66 and Directive 87, arose. Considering this, in Enron versus Argentina, the tribunal, when was confronted with a jurisdictional challenge, decided that although the original investor had already assigned its claims to a new investor, it would still have the legal standing to bring claims forward against the host state. Under these proceedings, this interpretation would mean, and if this tribunal decides to accept the jurisdiction of the claimant, that both Mercuria First National Bank and Goliath National Bank could bring concurrent claims before this tribunal concerning the same measure, and that, members of this tribunal, could cause policy concerns to my client as a whole
Counsel,
state.
two questions that I have to you in that regard, if I may interrupt you, of course. First question is that wouldn't be the assignor, is stopped technically, if you think about logically, from bringing concurring claims if it has assigned or expressed at least a will to assign the claims to the assignee. And my second question to you would be that from as I see it right now, if I understand you correctly, and please correct me if I'm wrong, your argument is based on the premise that it is not possible to assign claims under investment treaties. So because I frankly speaking, try to grasp the gist of your argument, and from what I see it right now, you're arguing that it is not possible to assign investment treaty claims.
Thank you, Madam Arbitrator. Ten, do you still have a question? I sense that you were going to ask.
Yes, I did try to.
So I can address.
I did try to go ahead and respond to Nikita's question.
Thank you. So, Mr. Arbitrator, you brought two main questions that shall be answered under two main grounds. The first is that the assigner is a concern regarding the assigner being stopped from still bringing claims under the assignment agreement. Now, members of this tribunal, that does not hold true. the assignment agreement, although it contains provisions in which the original investor has waived its rights and obligations under the financing agreement, the assignment agreement is a domestic instrument, and the jurisdiction provided under Article 10 of the ASNEC Treaty would still be considered regarding that investor, even though it has assigned its claims. So in the sense, no, Mr. Arbitrator, the MFNB would not be stopped from doing so. Considering your second...
May I follow up on that real quick? Is there prohibition that claims are there any rules in the jurisprudence of investment tribunals, or maybe customary international law, or maybe even treaty law, which would allow us to develop a framework analytical framework which we can apply to the situation? Because what you're saying is that there are no rules for that, and because the assignment is made under domestic law, then that it should not be valid. Again, as I see it, but isn't that the case that, for example, there would one can still say that assignment would be valid if, in case of, for example, succession and insolvency? For example, when the assignee is a company which is created as a result of the insolvency proceedings, and by operation of law, it receives a certain claim. So in that case, it would also would not be valid?
No, Mr. Arbitrator, it is not the respondent's position that the assignment of claims is not possible in all circumstances regarding investment law. Rather, that this particular assignment pertains to expectations from a time the claimant was not an investor. For instance, in the FedEx case, the tribunal decided in favor of the assignment of claims, as it did not particularly regard any particular circumstances regarding the Haudenosaunee think parties. Rather, it was merely credit titles that were assigned to the new investor.
Counsel, but isn't it so that basically then your argument is based on the effect, on the scope of the assignment agreement? So basically, whether the claimant is able to purchase a whole scope of rights that is owned by the original investor, such as rights to bring claims, etc., as opposed to buying only like some part of them. And if that is the argument, how do you basically divide between those two cases? Because I'm trying to understand, because as the assignment agreement suggests, the claimant is the legal successor of the original investor in all senses for the purposes of the claim.
Mr. Arbitrator, so regarding the first question that you previously mentioned, that is regarding succession and insolvency, under these proceedings, the only party that is claiming bankruptcy is Mountaintop, and in this sense, the original investor is not at this stake. So it does not. This tribunal should not be concerned with this policy concern. Regarding your third question, rather, that claimant did not acquire all rights, and how does the respondent position itself under international practice? The respondent positions himself under Article 10 of the ASNEC Treaty that provides the jurisdictional requirements. And although it does not expressly provide the Haudenosaunee think parties requirement, it does state that an investor may bring claims associated to the investment. And in this sense, it is the respondent's position that these associations under these proceedings should be regarded by this Alto Tribunal and assessed under the merits of this dispute. The respondent, however, does not contest that nationality requirements have been imposed by Alto Tribunals as one of the policy concerns and one of the criteria to what would be considered an abusive process. However, the respondent is not questioning the Haudenosaunee requirement of the jurisdictional requirement, and the respondent would conceive that the assignment of that particular legal claim would be possible under the consent of the host state. Now, make no mistake, members of this tribunal, it is not respondent's position that consent is a general requirement under investment law, but it would be an exception to the fact that the original to the fact that the new investor, that is claimant, is bringing a claim forward regarding a time it was not an investor. So
Okay,
you see,
isn't it the case that the claimant did notify the assignment to the respondent state?
the claimant indeed notified respondent. However, at no point under the case files, this tribunal will find a consent from the host state. And the respondent did not address the assignment agreement, as the assignment agreement does not pertain to the jurisdiction of respondent. It is a domestic contract under the laws of Mercuria. And this is precisely why the respondent did not address that assignment. And members of this tribunal, the assignment, so in the sense, the assignment is a domestic instrument that could not prevent the claimant and that could not prevent the original investor from bringing a claim forward, and the respondent was not even considering the option that that assignment would assign also rights from the time the claimant was not an investor. So the protection of the treaty does not encompass that particular claim. Hoping to have, do you have a question, Madam Chair?
Can I just ask a question on that point, because you mentioned it earlier, leaving aside the timing for one moment, and I take your point on that. But in relation to the assignment giving rise potentially to two separate claimants and two separate claims under the treaty, if I'm understanding, you made the point earlier, and if I'm understanding your point correctly, you say that's a policy reason why this can't be the effect of these facts. But does the fact that two claims exist necessarily mean that those two claims could exist in respect of the same quantum, the same damages? Or could a claim be partly assigned and then you have two claimants and they can claim half the damages each? I understand damages are not before us today and may or may not be before us in the future. But just to that point, could you respond to that, please?
Madam Arbitrator, it does not necessarily mean that concurrent claims could arise, but the risk of concurrent decisions, conflicting decisions, and my client paying the same price twice is already a policy concern that should be considered by this tribunal. Hoping to have clarified my first submission, I move forward to my client's second argument, that Mr. Perry Mason should not compose this tribunal as the circumstances surrounding him give rise to justifiable doubts towards his impartiality. Members of this tribunal, I would like to first establish the facts surrounding Mr. Mason, then the applicable rules and the respondent's interpretation considerations. Members of this tribunal, two are the grounds for the challenge: Mr. Mason's previous appointments in concurrent proceedings regarding the same directive, and second, the reaffirmation of his position by means of his public statements. Members of this tribunal, Hero Plants versus Well Falcom and Sea Energy versus Well Falcom are the two only arbitrations concerning Directive 87, apart from this one, that have arose from the Directive 87. And in both of these proceedings, Mr. Perry Mason has been appointed by the side of the claimants to assess and to evaluate those arbitrations as an arbitrator, as a decision maker. Considering this, the respondent is well aware of, please, Madam Arbitrator, do you have a question?
Yes. Counsel, can I just push you a little bit on that point? You mentioned that Mr. Mason did not disclose his involvement in Hero Plants. Now, if that was the only factor we were looking at, the fact that if we find that he should have, but he did not disclose that involvement, is that alone sufficient to disqualify him?
It is not, Madam Arbitrator. Alone, the non-disclosure is not a sufficient ground for the challenge of Mr. Mason. However, it is the respondent's position that these grounds should be analyzed cumulatively as they are correlated between them. It is not simply the fact that Mr. Perry Mason was previously appointed, but rather that the apprehension of bias and the issue conflict caused by these previous appointments has been made available to the public by the part of Mr. Mason through his public statements.
Counsel, I may interrupt you for a second. So basically, you are now saying that the tribunal basically view the factors that can lead up to the challenge of Mr. Perry Mason cumulatively. Where does that come from? So what is the basis for such test? Because arguably one can present a different point of view and can say, look, if you look at different facts that do not separately constitute a ground for a challenge, if you sum up zeros many times, the result is still zero, or that is not the case.
This is not the case, Mr. Arbitrator. Alone, these grounds have an impact on the decision of this tribunal regarding the challenge. However, analyzed cumulatively, it is then that it becomes clear the issue conflict here. Members of this tribunal.
Maybe just a small follow-up or really brief follow-up question from my side. Would you point us maybe to a decision of a tribunal which viewed grounds for a challenge cumulatively?
Mr. Arbitrator, I see that my time is about to elapse. Can I ask for an additional 2 minutes to conclude my submissions?
You certainly may. In fact, you can have 3, 1 to answer the arbitrator's question because you've had a lot of questions, and then 2 to wind up, indeed.
Thank you, Madam Chair. So, Mr. Arbitrator, a decision that could be used as a ground for the challenge of Mr. Mason is C.C. Devas versus India, a case law that also applied the ancestral rules in which the tribunal decided to accept the challenge of Professor Vicuña under 2 very similar grounds. First, his previous appointments in Argentina cases, and members of the tribunal, Argentina was not a part of C.C. Devas, only related to the subject matter of the dispute. And following from those 2 and afterwards 3 decisions, Professor Vicuña wrote an academic article reaffirming his position in those 2 decisions. Now, the claimant may allege that the C.C. Devas provides for a higher threshold or circumstances different from these proceedings, as there are differences between the previous appointments of Mr. Mason and his public statements. However, members of this tribunal, the differences are not so strong. You see, the other 2 arbitrations are also concerning the same subject matter, that is the attribution, that is the directive and the phase out of coal-fired power plants in the Republic of Leyte and Welfalchem.
Counsel, but finally, do you know what was specific opinion of Mr. Mason on those issues, or you basically try to elucidate his opinion from the evidence?
The award has not yet been published, Mr. Arbitrator, but it's clear from the case files and his interview in the Arbitration Station podcast and the social media post. I'd like to invite this tribunal quickly to page 49 of the case files so we can address that issue. Page 49 is the 2nd page of the transcript of the Arbitration Station interview. And on the 3rd paragraph, from top to bottom, I read, "On the other hand, I do not see how climate change adds anything new to the debated investment law that would make it worthwhile to the next generation to rehearse the policy power arguments again. Also, whether climate change treaties, if they can be considered treaties at all, can come into play as a part of applicable law in investment treaty arbitrations is understandably subject to debate." And in the paragraph just on the top of that, he states that he has seen this happen in previous cases. So, members of this tribunal, do not mistake Mr. Mason's subtle wording of saying that something is subject to debate or that something does not add anything new. There is a clear issue conflict here and a predisposition of bias, although he did not use imperative wording. He has seen that happen, members of this tribunal. And when he saw that happen, he created a biased opinion regarding Welfalchem and not Respondent. And now my client's procedural rights are at stake here to be decided by the members of this tribunal. If there are no further questions, I would like to simply summarize my pleadings, being first, that claimant has no legal standing under these proceedings, and second, that Mr. Perry Mason should respectfully be removed from the tribunal. Thank you.
Thank you very much, Ms. Peers. Ms. Honoré, are you responding or? Yes, thank you.
Thank you, Madam President. President of the Tribunal, Members of the tribunal, my name is Shannon Honoré, and together with my co-counsel, we represent Goliath National Bank, that is the claimant in the present proceedings. I will make two submissions following respondent's order. First, this tribunal has jurisdiction over GNB's dispute, and that is because GNB owns a protected claim and a protected investment. And second, this tribunal should dismiss the challenge against Mr. Mason as it is without merit. His involvement in unrelated cases and career tips do not give rise to justifiable doubts as to his impartiality. Turning to my first submission, that is, this tribunal has jurisdiction to hear GNB's claims. When it concluded the assignment agreement, GNB effectively acquired all of the rights and claims arising from the financing agreement, including any right to claim compensation from LEOC. Therefore, GNB did validly acquire a claim against LEOC from MFNB, who therefore relinquished such claim. In this regard, respondent has acknowledged that the treaty is silent as to the assignability of treaty claims under the ASNEC Energy Treaty. Such silence, contrary to respondent's assertion, should not be interpreted as a prohibition, to quote from opposing counsel. Rather, what is not prohibited under international law is allowed. Respondent has relied on the existence of subrogation clauses in some BITs to argue that the assignment of treaty claims is dealt with through these subrogation clauses.
Counsel, sorry to interrupt you. Could you give me some authority for the proposition that you just made, that under international law, what is not prohibited is allowed?
Yes, Madam Arbitrator, this statement, this specific reference comes from the Lotus case, but it was also affirmed by the Tokyo Tokeles Tribunal, which held that it is not for tribunals to impose limits on the scope of BITs not found in the text. And this is why GNB submits that what is not prohibited specifically is allowed. Coming back to the silence.
Just a follow-up question on that. So your statement relates to what's not prohibited under the specific treaty should not be allowed, as opposed to the much broader statement, which I think the question related to what's not permitted under international law, what's not prohibited under international law as a whole. You just are talking about the treaty on the basis of those authorities.
Yes, Madam Arbitrator, we are talking about this treaty, and specifically, respondent relied on the existence of subrogation clauses, which again were introduced in some BATs specifically to deal with the question of insurers stepping into the shoes of the insured parties. And in this regard, I invite the tribunal to note that in the CME case, the Netherlands and the Czech Republic had included in the treaty, in the BIT, a subrogation clause. However, they still considered that the BIT was silent as to the assignment of treaty claims and agreed that despite the silence of the treaty, such assignment of treaty claims was allowed under their BIT. And this is why the silence of the treaty is not conclusive as to the prohibition of assignment of treaty claims. Members of the tribunal, this is not a question of temporal issue. A temporal issue would only arise if the purported assigner did not have the nationality required at the moment of the breach. And this was explained in some cases, such as the Phoenix Action case.
Counsel, could you help me with when you are defining the date of the breach? Because from what I understand, the law 66 was promulgated on 6 July 2016. And at the time, the investor holding the investment was MFBN. But obviously the claimant, who then submitted the claim in the notice of arbitration, they took that over only in 2017. I'll be grateful for your elucidation. Thank you.
Well, Madam Arbitrator, let me clarify that, first of all, claimant's case is not based on Law 66, and I will come back to it in relation to the challenge, as it has its relevance with respect to the similarity between the cases. But there cannot be an assignment of a treaty claim before such claim arises. And as to Madam Arbitrator's question, the alleged breach to quote from Madam Arbitrator's question, did occur in 2016. However, this does not have an impact on the assignability of MFNB's claim to GNB. And this is because case law amply suggests that the assignment of treaty claims is permissible. And in this regard, I would like to invite the tribunal to follow the reasoning adopted by the tribunal in the Schooner against Poland case. In this case, much like Respondent did in its response to the notice of arbitration, the respondent, which was Poland, had contested the standing of an assignee on the grounds that it did not own the investment at the time of the alleged breach. However, the tribunal still found that it had jurisdiction, and I will quote from the decision of the tribunal in this regard. There is no dispute that W, the assignor, made an investment in Poland and could have brought a claim under the BIT. W, the assignor, has assigned all its assets, including any legal claims relating to those assets, to A, the assignee. A, like W, is a US company. In these circumstances, the tribunal is of the view that A, as the successor to W, has made an investment in Poland and has standing to bring the claim. The same line of reasoning applies in the present proceedings, members of the tribunal, and this is because GNB has the same nationality as MFNB and was therefore protected under the same treaty.
Counsel, can I interrupt you for a quick second? I just have trouble understanding the framework for the assignment. So basically, from what I understand, the case suggests that the assignment was made under the laws of Mercuria, if I'm not wrong. And correct me, please, if I'm wrong, but in any event, under the domestic law. So I'm just trying to wrap my head around the issue of how is it possible to assign an international law claim using domestic law instrument.
Well, Mr. Arbitrator, tribunals have found that as long as the assignment agreement itself is valid under domestic law, then it should not be an obstacle to the assignment of the claim under international law. And in this respect, I would like to quote from the, I would not like to quote, sorry.
So you don't have anything to support that proposition?
I do, I just don't have the exact quote, Mr. Arbitrator, but you can rely on the Wintershall case in which it was explicitly held that as long as the domestic law allows the assignment, then there is nothing to prevent an investor from assigning its claim to an assignee. And again, the case law suggests that this is possible, not only the Schooner against Poland case, but also African Holding, in which the tribunal held that the assignee could assign a claim that it had acquired from the previous owner. And with respect to respondents' concern that it may face concurrent claims from both MFNB and GNB, first of all, GNB agrees with Mr. Arbitrator's question and finding that MFNB would be stopped from asserting such claim. And that is because the evidence through the assignment agreement suggests that MFNB has relinquished its right to bring the claim against LEOG. In any event, GNB, like MFNB, is an investor under the ASNEC Energy Treaty, and this is why it should be allowed to bring its claims following the reasoning adopted by several tribunals. And respondent has not contested that GNB owns an investment for the purposes of this treaty, and this is why this tribunal has jurisdiction over GNB's claims. Moving on to my second submission, which is that the challenge against Mr. Mason should be dismissed as it is without merit. Members of the tribunal, allow me to clarify one very important point. GNB's case is not about the closure of coal-fired power plants as of 31st December 2028 onwards. GNB's case is about LEOG's measures introduced by Law 72 that have adversely distorted competition on the energy market during the remaining operating life of Taikedia 1, that is to say, from 2016 until 31st December 2028. And Respondent has relied on Mr. Mason's appointment in allegedly similar cases to argue that an issue conflict arises, and also on Mr. Mason's public statements. However, considering that GNB's claims is only directed at Law 72, there can be no similarity between the disputes brought against Falcon and the present dispute. That is because there is no evidence on the record to suggest that Falcon has provided similar support schemes as the one introduced by LEOC. And therefore, there is nothing on the record to suggest that the similar measures were at stake in both Hewer Plants and Sea Energy and the present dispute. Should the tribunal need any further convincing, it will note that the disputes concern different parties, that is to say, different respondents, one being LEOC and the other being Falcon, but also different claimants. And in this regard, GNB would like to stress that it is not a plant operator, but rather that it is a creditor, and it has rights under the ASNAC Energy Treaty in this quality, in this capacity.
Counsel,
And again,
can I interrupt you for a brief second? So basically, if we look at the exhibit R9 of the case, the exhibit R9 outlines more or less the background of the case that was decided by Perry Mason, among others. And then we have another exhibit, which is R10, which is basically Mr. Perry Mason on Twitter or on some social network quoting this article and saying, quote, "Proud to have served as arbitrator in this groundbreaking case on climate change," unquote. So it seems to me that here Mr. Mason basically says that more or less the issues that have been laid out in the article by the reporter pertaining to the award, obviously, are more or less correct. So the interpretation of the award given by the reporter is correct. And not only he does that, he also says that the interpretation that he did is nothing else than groundbreaking. So my question is, if a person has made up his mind and called something which he wrote groundbreaking, what are the chances of him remaining objective?
Mr. Arbitrator, allow me to answer your question in 2 points. First, this tribunal will note that Mr. Mason's tweet and the article do not actually go into the detail of what has been discussed. And as Mr. Arbitrator has already noted, the award is not published, and therefore we do not know the content and the extent of the discussions held by the tribunal. And in this regard, Respondent—
I'm sorry, but we do know the outcome, don't we?
We do know part of the outcome. However, Mr. Arbitrator, it is not particularly relevant in this specific case because Respondent has conveniently chose to ignore the fact that on the attribution, the tribunal has followed the Respondent state's reasoning, which is in line with Respondent's reasoning in the present dispute also. And this is why in the Hewer Plants case, we do have information that attribution of conduct that the conduct was attributed to Falcon with respect to the open cast mine. There is no issue of open cast mines in the present dispute, and therefore the fact that the tribunal concluded to a violation of the fair and equitable treatment standard in relation to said open cast mine is irrelevant for this present tribunal. And as to my second point, it actually shows that Mr. Mason did not fail to disclose anything. First of all, the fact that he described this award as groundbreaking is only in relation to the fact that it was the first of a series of investment arbitrations brought against states implementing the coal directive. That is only professional achievement that is celebrated in the present dispute and not the content of the award itself. As to the alleged failure to disclose, not only was Mr. Mason not under a duty to disclose, but the test also to consider a failure to disclose as a disqualifying ground was set out in the Tidewater against Venezuela case, in which it was held that non-disclosure would itself indicate a lack of impartiality, only if the facts or circumstances surrounding such non-disclosure are such gravity, whether alone or in combination, as to call into question the ability of the arbitrator to exercise independent and impartial judgment. And this is not the case in the present dispute. As to the test which I was referring to, it was also explained in the Suez against Argentina case that it should be that it should turn on whether the failure to disclose was inadvertent or intentional. And it cannot be intentional in the present proceedings, because Mr. Mason did retweet the article, and therefore there was no intention on his part to hide his appointment in the Hewer Plans case. As to the Sea Energy case, it was completely at his own initiative that he disclosed this in the response to the notice of challenge. As to respondents' reliance on the C.C. Davis case, contrary to respondents' assertion, it does not rest on similar grounds. First of all, Professor Vicuña, who was challenged and disqualified in the C.C. Davis case, had published the article following the annulment of 3 awards in which he had sat, whereas in the present dispute, the arbitration podcast interview occurred before Mr. Mason was even appointed in the present case. And respondent again conveniently forgets to mention that another arbitrator was challenged in the C.C. Davis case, and that is Honorable Lalonde. And in his case, the challenge was dismissed because the mere appointment in supposedly similar cases was not sufficient to lead to disqualification. Now, as to Mr. Mason's career tips, I invite the tribunal to go to page 49 of the record, where it will find the arbitration podcast interview. The test to assess whether public statements may lead to disqualification was explained in the Urbuster case, and it is one that is very clear for this tribunal to follow. Statements must be specific and clear enough, and such specificity is manifestly lacking from Mr. Mason's public statements. The only case in which public statements led to disqualification is the Perenco against Ecuador case. And by contrast, in that case, Judge Bra's comments, Judge Bra had specifically named Ecuador while giving his interview. There is absolutely no reference to Leoc or Well Falcon, for that matter, in the interview that respondent grounds its challenge on. And therefore, this tribunal should follow the reasoning of the Urbuster tribunal, which held that the mere showing of an opinion, even if relevant in a particular arbitration, is not sufficient to sustain a challenge for lack of impartiality. As to the comments that respondent has specifically directed the tribunal at, they do not reflect Mr. Mason's position on any of the issues discussed in the present dispute. This is why members of the tribunal, in view of the lack of similarity between the Sea Energy and Hewer Plants case and the present dispute, and again, GNB's claim is exclusively grounded on Law 72, which does not appear to be similar to any measures taken in Well Falcon, and in view of Mr. Mason's appropriate conduct all along this arbitration, GNB respectfully requests this tribunal to dismiss the challenge against Mr. Mason.
Just ask a question on going to your point on specificity of the comments, and particularly for the arbitration podcast comment. And the question put to Mr. Mason was, you hear a lot more and more talk about so-called climate change arbitration. Would you consider this a prospective area? What do you understand? That's at page 49, yes, where you took us. What do you understand climate change arbitration to mean? And I ask you the question in the context of your submission on lack of specificity.
Yes, Madam President. First of all, as Madam President noted, the question was actually aimed at providing career tips for young practitioners. And this was the context in which Mr. Mason made his comments. As to Madam President's specific question as to the definition of climate change arbitrations, these would be cases in which the state relies on environmental measures to justify the violation of its obligations under an investment treaty. However, this general definition is not sufficiently specific to be applied in the present dispute. Many tribunals many arbitrators serve on cases revolving around the same issues, such as the fair and equitable treatment or expropriation. And if an arbitrator was disqualified on the sole ground that he has faced similar factual or legal issues in other arbitrations, the International Investment Arbitration Framework would collapse. And these are not just GNB's words, these are the words of a task force report on issue conflict in investor-state arbitration.
Okay, thank you.
Do we have time for one more question, Wendy? One of the key tenets of your argument, counsel, is that the claim by the claimant is brought on the basis of law number 72. But if I look at the notice of arbitration, this is what the claimant says. Paragraph 12, or rather page 6, line 95, right? It says, after the sort of the first half of the sentence, respondents suddenly fundamentally changed this approach to domestic regulation of the coal sector by adopting the law 66 of 2016, and then it quotes the law on 6 July 2016, forcing T1 to shut down 26 years before the end of its expected 40-year lifetime. So is it correct that claimant's claim is really primarily based on law number 72?
Yes, Madam Arbitrator, and that is because the relevance of law 66 to the present dispute was simply to provide the backdrop against which law 72, that is the measure in contention, was introduced by LEOC in its legal framework. And following respondents' response to the notice of arbitration, and in particular the question of attribution was raised as to law 66, the claimant only decided to ground its claim on law 72.
Nothing further.
Very good. Thank you very much, Ms. Honoré. And Ms. Pearce, are you responding? Thank you.
Yes, Madam Arbitrator, thank you. Members of this tribunal, for 30 years now, the Vienna Convention on the Law of Treaties have well-structured and cautiously prescribed what is the interpretation of the silence of the treaty, as so for the claimant to say that what is not prohibited is allowed. Members of this tribunal, for a whole state to file a claim against an investor is not prohibited under this treaty, but it is not allowed either. Considering this, I would just like to make a distinction between the sole case law in which the claimant relied upon its first submission, that is the Schuner versus Poland. That case pertained the assignment of shares from a bankrupted company, and there were measures taken from the whole state after that assignment. Thank you.
Thank you very much. Ms. Perez, do either of the co-arbitrators have any additional questions before we move on to the next issue? All right, thank you both very, very much for that. And oh, I'm sorry, you have a further response.
Yes,
forgive me, Ms. Honoré, and thank you for getting my attention. Forgive me, please go ahead.
Thank you, Madam President. As to respondents' first point regarding the interpretation of the words through the use of the Vienna Convention on the Law of Treaties, it is important for this tribunal to note that the interpretation guidance provided in the Vienna Convention indicates how to interpret the words of the treaties themselves, not the silence of the treaties. As to respondents' contention that claimants' arguments are based on only one case, this is simply not true. Not only has claimant relied on the Schuner against Poland case, but it can also rely on the African Holdings against Congo case, the reasoning adopted in Daimler, in Gempus, and many other cases. Thank you.
Thank you very much. And I'm not getting any indication from co-arbitrators, so that's excellent. Thank you very much. All right, now we will turn to your co-counsel and to the next issues, please. I think we start here with the claimant.
Can you hear me well, Madam President, members of the tribunal?
We can, thank you very much.
Madam President, members of the tribunal, my name is Ana Cuartero de Vidiella, and I will proceed to deal with the two remaining issues on behalf of GNB, the claimant in these proceedings. GNB has two main submissions to make before this tribunal today. First, that Law 72, enacted by the Laocoon Parliament, is attributable to LAOC, and therefore GNB is entitled to bring LAOC in front of this tribunal today. And second, that Law 72 violates the FET standard in the treaty, and therefore this tribunal should hold LAOC responsible. Before turning to claimant submissions, GNB would like to recall that two laws were enacted by LAOC following the ASNEC Coal Directive. Law 66, that imposed the phase-out of all coal power plants by 2028, and Law 72, that put in place a so-called Energy Transition Plan. GNB does not challenge Law 66, but Law 72 only, as mentioned by my co-counsel. And this is because GNB is a creditor, not a shareholder. Its primary concern is that Taikadia 1 is able to repay the loan installments. The loan was to be reimbursed by 2030, which is to say, only 2 years after the phase-out. For this reason, Law 66 imposing the phase-out has a very limited impact on Taikadia 1's ability to repay the loan installments and only creates prospective damage. To the contrary, Law 72 affects Taikadia 1's ability to repay the loan immediately, causing present damage. By granting priority access to the electricity grid to renewable energy operators only, and creating a new state-owned entity in the market of renewables, the competition in the electricity market is distorted and does not allow Taikadia 1 to be profitable. And as such, Taikadia 1 is unable to repay the loan installments to GNB. Moving on to claimant's first submission now, which is that Law 72 is attributable to LAOC. GNB will make 2 points to this regard. First, that the ASNEC rules do not prevent Law 72 from being attributable to LAOC under Article 4 of the Articles on the Responsibility of States. And second, that the only exception in which the application of Article 4 of the Articles on the Responsibility of States will be displaced, which is the situation of full secondment under Article 6 of the Articles on the Responsibility of International Organizations, is not met in the present case. And therefore, Law 72, enacted by the Laocoon Parliament, is necessarily attributable to LAOC. Members of the tribunal, there is a provision in the ASNEC rules regarding the attribution of conduct, and this provision is Article 120 of the ASNEC Founding Charter, which is to be found on page 33 of the record. This provision states that attribution will be governed, in particular, by Article 6 and 7 of the Articles on the Responsibility of International Organizations. Now, the expression "in particular" is included because the Articles on the Responsibility of International Organizations apply without prejudice to the rules set out in the Articles on the Responsibility of States, as specifically mentioned in the commentaries of both sets of articles. In other words, the Articles on the Responsibility of International Organizations apply to international organizations, and the Articles on the Responsibility of States apply to states. Therefore, the general principle is that both sets of rules apply cumulatively. Accordingly, there is nothing in the Articles on the Responsibility of International Organizations that would prevent the application of Article 4 of the Articles on the Responsibility of States. And under Article 4.1 of the Articles on the Responsibility of States, Law 72 can only be attributable to LAOC. This provision reads as follows: the conduct of any state organ shall be considered an act of that state under international law. Now, the Laocoon Parliament is LAOC's legislative organ, and therefore any laws taken by the Laocoon Parliament can only be attributable to LAOC under this provision. Unless there is a special rule of attribution, characterized as a lex specialis under Article 64 of the Articles on the Responsibility of International Organizations, which deals, for instance, with special rules in the European Union context, which is not the case in the present dispute, there is only one exception in which these articles would provide that a certain conduct could be attributed to the international organization only, thus displacing the application of Article 4. And this exception is the limited situation of full secondment that falls within the scope of Article 6 of the Articles on the Responsibility of International Organizations. And GMB will now proceed to demonstrate that these exceptional circumstances are not met in the present case, and therefore Law 72 can only be attributable to LAOC. Full secondment, in the meaning of Article 6 of the Articles on the Responsibility of International Organizations, refers to the very particular situation in which a state organ stops exercising its functions in order to exercise only the functions of the international organization under the sole authority of the international organization. To provide this tribunal with an example, GMB would like to refer to the World Health Organization Executive Board. This board is composed by 34 members that used to exercise functions in the field of health. Then, when they are elected to sit in the executive board, they completely stop exercising those previous functions to exercise only functions of the World Health Organization under the authority of the World Health Organization. As a result, their conduct is fully assimilated to the one of the World Health Organization. And this situation of full secondment, members of the tribunal, cannot occur in the case of the parliament of a state, which can never stop acting for the state. And as a result, the Laocoon Parliament could never be fully seconded to the ASNEC in the meaning of Article 6 of the Articles on the Responsibility of International Organizations. And since these very particular circumstances cannot be met in the present case, the Articles on the Responsibility of States apply, and therefore Law 72, taken by a Laocoon organ, can only be attributed to LAOC under this general rule. And GMB is therefore entitled to bring LAOC in front of this tribunal to claim it was not treated fairly and equitably as required by the treaty. Which brings me to my second submission, that is, that Law 72 violates the FET standard included in Article 2 of the treaty. And this for two main reasons. First, because Law 72 unduly impairs GNV's investment. And second, because Law 72 frustrated GNV's legitimate expectations. Moving on to the first point, which is the impairment of GNV's investment. According to the Escosol Tribunal, measures unduly impairing an investment can, in and of themselves, violate the FET standard. And in the present case, Law 72 impairs GNV's investment by putting in place unreasonable and discriminatory measures.
Counsel, I'm sorry to interrupt you, but this concept of undue impairment of investment and fair and equitable treatment, you've quoted, I believe now, just one case. Are there any other cases which apply basically, which impose liability on states for breach of fair and equitable treatment purely on the basis of undue impairment of investment? And if so, what are the criteria that are used by the tribunals to distinguish the cases of undue impairment? Thank you.
Precisely, Mr. Arbitrator. Different cases have decided on the impairment on the investment, and these for several reasons. Claimant,
which cases? Which cases? If you be so kind to quote them.
Claimant referred to the Escosol Tribunal for an impairment by unreasonable measures, but could also refer, for instance, to the Forsat versus Spain case or to the Electrobel versus Hungary case for an impairment by discriminatory measures. And this will come as a second point in Claimant's submissions.
So you're basically arguing discrimination then. I'm just trying to catch the gist of your argument. I'm sorry.
We are arguing, Mr. Arbitrator, an impairment as provided in Article 2 of the treaty, which states that no contracting party shall in any way impair by unreasonable or discriminatory measures an investment. And it is GMB's case that in the present dispute, Law 72 puts in place both unreasonable measures and discriminatory measures. With regards to the reasonable measures, a reasonable measure, in the words of the AES Summit Tribunal, is a measure that is adopted with a rational policy and where there is an appropriate nexus between the state's public policy objective on the one hand and the measure adopted to achieve it on the other. This is to say that the measure is necessary. Now, GMB does not contest the first point of the standard because dealing with environmental issues and promoting renewables may indeed, in the abstract, be a rational policy objective. What GMB is contesting is the nexus between the state's public policy objective and the measure itself, and argues that Law 72 is not a reasonable measure. And this is because, in the present case, less restrictive alternatives were available. This standard has been set out by investment arbitration tribunals such as the RWE versus Spain Tribunal. In the present case, member states were able to assist electricity producers in any form and methods. And yet, instead of using this room of maneuver given by the ASNEC Coal Directive to help existing operators in the coal sector, including GMB, LEIOC introduced a support scheme from which only operators in the renewable sector could benefit. As an alternative, LEIOC could have actually helped transitioning since it put in place a so-called energy transition plan. This tribunal should note that the cost of replacing a power plant such as Taicadia 1 with an installation of equivalent capacity producing renewable energy is extremely high. Converting into a solar plant, for example, which would be one of the cheapest options, would cost around $900 million. Now, no coal plant facing a shutdown such as Taicadia 1 could ever gather such upfront investment to secure the conversion. And less restrictive alternatives surely existed. To provide the example of Hungary, Hungary decided to phase out the coal sector by 2030 in a similar manner that LEIOC. However, Hungary put in place what was called a just transition from coal to renewable energy sources. And Hungary granted subsidies or tax exemptions, and most importantly, it did not put in place any priority access to the electricity grid. This is a fundamental difference because if operators with priority manage to satisfy the demand for electricity, operators with no priority cannot make any profit. And this
also,
is...
Sorry
Yes,
to interrupt you. This is quite an important question. So this case is important in particular because we're talking about climate change. And the reality is that governments around the world are starting to see that they need to commit themselves to international obligations, right? For example, to limit emissions. Now, what you're telling me, what I'm hearing is that you are contesting the way that the transitioning, that LEIOC has decided to implement the transitioning. And that is why you are contesting law number 72. Now, can you help me with what is the extent to which states should have the flexibility to regulate? And how do you balance that against what you're asserting to be sort of improper impairment of an investor's rights? How do we chart that cost?
Madam Arbitrator, it is GMB's submission that indeed the environment is important and should be protected. However, states have also an obligation to protect the investors' rights under the treaty, such as the investors' legitimate expectations under the treaty. And Madam Arbitrator, GMB would like to point out that although LEIOC states that it was conscious about the environment, it put in place discriminatory measures that were not helping the environment. This is because LEIOC put in place a support scheme from which biomass plants could actually benefit. And this is telling because these biomass plants are actually more polluting than a state-of-the-art coal-fired power plant such as Taicadia 1. And this brings Claimant to its second submission, that is that these measures were also discriminatory.
Counsel, but on that point, it will be a bit difficult for this tribunal to make a decision on the basis that we consider that biomass plants are more polluting than coal-fired plants. I mean, that I think might well be within the remit of a state to decide on its own.
Of course, Madam Arbitrator, the state has discretion to decide what measures to put in place. However, the state cannot put in place discriminatory measures. And the test set out in the Electorable versus Hungary Tribunal, which is to say that a measure is discriminatory when investors in the same circumstances are treated differently without rational justification, is met in the present case because the respondent put in place a support scheme from which biomass plants could benefit. Yet, this does not have a rational justification since these plants are actually more polluting than a state-of-the-art coal-fired power plant, such as
Counsel, but do you know of any other cases where coal producers are treated unequally between each other? So you're basically saying that coal producers as a class are treated unequally with the producers of renewable energy.
Yes, Mr. Arbitrator.
But in between themselves, the producers of coal energy are treated equally.
Mr. Arbitrator, these two different operators in the renewable sector and operators in the coal sector are considered by the International Energy Agency operators in like circumstances. And this is why GMB submits its investment has been impaired by discriminatory measures. And this, however, if somehow this tribunal decided that this law 72, did not impair GMB's investment, it is not to say that Law 72 is fair and equitable, since it also breached Claimant's legitimate expectations. Claimant's legitimate expectations were based on commitments that were specific and that were made by the Taicadian governor. Investment arbitration tribunals, such as El Paso or the Mazda Tribunal, have stated that even official statements without legal force create protected expectations if they are specific as to their addressee and their object and purpose. In the present case, the government...
But I'm sorry to interject, but how can you compare the present situation, or please explain us how do you draw the comparison between present situation and cases such as El Paso or Mazda that you've just quoted? And what were the representations made to the investors in Mazda and El Paso? And what were the representations made to the investor in the case at hand? Thank you.
Thank you, Mr. Arbitrator. GMB acknowledges that, for example, in Mazda versus Spain, the specific representations were specific commitments made in the law of Spain. However, the reasoning from the tribunal in Mazda should also be taken into account with regards to the specificity of the expectations. I see that my time is running up, so I would like to request this tribunal for 1 additional minute to conclude my submission on legitimate expectations and wrap up.
You could have 2 if you also answer the following. When you're wrapping up, could you please very briefly address whether Article 7 of the treaty also has an impact on the legitimate expectations, as is the environmental aspects provision on the legitimate expectations of the investor.
Yes, Madam President.
You can have 3 minutes. It was a big question.
Thank you, Madam President. And Claimant submits that this test with regards to this specificity has to be taken into account. Now, the governor is a direct extension of the power of the Laocoon government, as specifically provided in the record. And the governor signed a document.
Council, can we just park the governor for a moment and just talk in general terms about what are the criteria of specificity for the representation? Is there a test that is used by the tribunal to determine whether the representation is specific or not?
Yes, Mr. Arbitrator, they have to be specific, first, as to their addressee, and second, as to their object and purpose. And in page 10 of the record, this tribunal will find that both criteria are met.
And if I may, what could be the purpose of an oral representation made by the governor? And also, if I may, how can you elucidate the specific promise made made orally? So how can you pin it down? That's my question. And is it fairly possible to pin it down, as a matter of fact?
GMB acknowledges that in some cases, oral statements or political statements have been held to have less value than written statements. However, in the present case, not only do we have a written statement, but we have a written statement that was signed. And for this reason, this tribunal should find this document as a valid document giving rise to legitimate expectations on behalf of the bank. Indeed, the governor committed that the plant will be economically beneficial. Yet, due to Law 72, Takedia 1 is not able to repay the loan installment. And this is precisely—
Council, but how can, just if we pause there for a moment and think logically, how can a governor promise that a plant will be profitable when the profitability of a plant depends in many ways, in many respects, on the investor itself? So is it your claim, let's take it in steps. Is it your claim that the specific representation that was made to MFNB was that the plant is going to be profitable? Is that what you're saying?
The GMB's claim is that LAOC would not impair the profitability of the plant, and Takedia 1 would still be able to repay the loan installments.
Okay, so let's pin it down. So the promise is that LAOC will not impair the profitability of the plant. So where do you basically get this precise formulation from?
LAOC granted the profitability of the plant as stated on page 10 of the record in the last paragraph. The governor committed to do everything in its power to ensure that the operation of the plant will be economically beneficial. And this was—
Yeah, but isn't it the case that the measures that were imposed that hurt the profitability of the plant were not in fact imposed by the governor?
It is true that the measures were not enacted by the governor, but by the—
And the governor probably has little power to stop what was happening, doesn't he? So how do we put this all together with the representation that you're presenting us that was made to you?
The governor, as specifically provided by the record, is a direct extension of the Laocoon Parliament. Therefore, any commitments made by the Takedian governor were made on behalf of LAOC and in the Laocoon.
But when the commitment was made to you, weren't you supposed to, as an investor, to reasonably assess the scope of the powers that is vested in the governor?
Mr. Arbitrator, indeed, the duty to make a due diligence is not, in the words of the Bellenergia versus Italy Tribunal, a full and extensive duty of due diligence to be done by the investor. Rather, the investor has to make a reasonable due diligence. And in the present case, a reasonable due diligence was certainly made, as provided by page 11 of the record. This due diligence not only encompasses regulatory due diligence, but also financial projections, and this is precisely why GNB reasonably expected Taicadia 1 to be profitable.
But do we, apologies, do we know whether this due diligence actually took into account the nature of the statements made by the governor?
Yes, Mr. Arbitrator, indeed, as provided on page 11 of the record, which is Exhibit C3, this due diligence took into account various materials, included the minutes of the meeting with the Taicadian governor. And this is why GNB submits there were legitimate expectations in the present case. And now I would like to address Madam President's question with regards to the right to regulate clause included in Article 7 of the treaty. GNB submits that this clause regulating environmental aspects is simply a clause stating the contracting party's intention to regulate in environmental matters, but this clause does not impose any obligations on the contracting parties. It merely states that the contracting parties decide to protect the environment in accordance with the preamble of the treaty and in accordance with other international obligations, and this is further strengthened by the inclusion of this clause in the treaty. Members of the tribunal, LEOC had
just two very quick follow-up questions. I know you're trying to wind up. The Article 7.1, do you accept that that's a progressive provision, number one? And number two, do you accept that Article 7 informs the investor's legitimate expectations?
Madam Arbitrator, it is GNB's submission that no stability requirement of the legal framework, that this specific clause does not mean that the environmental framework is necessarily going to change. And this clause does not mean that the state is precluded from acting in accordance with the actual obligations contained in the treaty, such as the fair and equitable treatment standard. Therefore, if the respondent state wishes to exercise its right to regulate in environmental matters, it has to be mindful of the expectations of the investors that are protected under the fair and equitable standard in Article 2 of the treaty. And in order to conclude, GNB would like to restate that LEOC had a duty to implement the coal directive, but it also had wide discretion to introduce all possible measures to smoothly help coal energy operators to transition towards green energy. And yet, instead of helping these operators to convert, Law 72 put in place unreasonable and discriminatory measures that impaired GNB's investment and frustrated its legitimate despite all the assurances made by LEOC. And GNB is therefore asking this tribunal today to order LEOC to comply with these international obligations and compensate GNB's losses.
Madam Chair, you are on mute.
That to happen. Ms. Cortejo de Videlia, thank you very much, and thank you for dealing with our interruptions. We will hear from you further. Mr. Martins, I think we have you next. Thank you.
Thank you, Madam Chair. Members of the Arbitration Tribunal, opposing counsel, good morning. As previously introduced, my name is Italo Martins, and I'll be presenting submissions on behalf of Respondent on the merits of this dispute. Members of the tribunal, 12. 12 is the number of years the United Nations Intergovernmental Panel on Climate Change, as of 2018, gave the world to radically reduce its CO2 emissions before climate change became irreversible. It is in this context that the ASNEC Council approved by a majority an ASNEC directive phasing out of coal-fired power plants in the region to address the catastrophic floods that were happening in the region, and just on LEOC took over 85,000 lives and damaged over 50,000 homes. Members of the tribunal, the respondent will address the submissions of the claimant in the order they were presented, but firstly, the respondent wishes to clarify that it was under the impression that claimants' submissions were based on Law 66/2016, and it being a breach to the expectations of the original investor. As was questioned by Madam Arbitrator Tam to the claimant, the reasoning behind the notice of arbitration is the passing of Law 66/2016, which allegedly changed the regulatory framework. Not only that, but the exhibits which were submitted with the notice of arbitration actually speak to the fact that the Taicadia 1 LLC would not allegedly be able to pay the loan on the basis of passing an enactment of Law 66/2016 and not on the basis of Law 72/2016. So if GNB's expectations were that the financing agreement would not be paid, this non-payment would be due to Law 66/2016 and not Law 72/2016, as is recognized under the case file by claimants' predecessors. Briefly, in respect of Law 66/2016, members of the tribunal, the co-directive that was issued by ASNEC is a binding directive upon all member states in the region with respect to the result to be achieved. And I invite the tribunal to follow me to page 17 of the case file, so to address what is the result to be achieved. Page 17, if the tribunal is with me, concerns the ASNEC directive, and on Article 7, Clause 1, provides, and I quote, in order to reach or exceed the association target set in Article 2, each member state shall reduce the percentage of its final gross production of energy from coal-fired power plants to zero by 31st December 2028. This is the binding result to be achieved according as to the ASNEC Council, and ASNEC thus exercises control over this specific conduct, the phasing out of coal-fired power plants, to which, in the notice of arbitration, claimants' concerns were directed against. But the claimant in this hearing has conceded expressly that it will not base its allegations on Law 66/2016, contrary to the notice of arbitration, and thus it falls upon the respondent to answer both that the measure is attributable to the respondent with respect to Law 72, and that Law 72 did not violate either the legitimate expectations of GNB and was not discriminatory against its participation in the coal sector. Now, with respect to attribution of conduct, members of the tribunal, it is true that the respondent will not allege that with respect to Law 72, the attribution of the conduct should be to the international organization. As to the international organization, it is Law 66 that must be attributed, as the result was binding, the phasing out of coal-fired power plants. Respondent acknowledges that it was its parliament that enacted Law 72, but as a measure to provide a viable alternatives for the operators of the coal sector to transition their plants from coal-fired power plants to plants that could burn biomass or any other alternative that could still comply with the binding directive issued by ASNEC. And in this sense, respondent acknowledges that it was responsible for implementing Law 72/2016, in as much as, Madam Arbitrator Tam, do you have a question?
Thank you, Counsel. Counsel, I understand that you are emphasizing the binding nature of the coal directive. Now, how do you draw the distinction between, on one hand, where a state under general international law signs up to a treaty and therefore it is bound by those obligations and it has to then implement those obligations via domestic law? That's on one hand, versus in this case where you are arguing that in fact it is an international organization that has somehow imposed the obligation, and therefore because in some way Laos had ceded those powers, it was effectively controlled. Could you explain that?
Yes, Madam Arbitrator. In fact, it is recognized, and specifically with respect to the European Union, for example, in WTO case law, that the member states may transfer competences to an international organization. And this specific respect, Madam Arbitrator, the ASNEC member states have transferred the competence on energy and environmental sectors. But it must be made clear there are several legal acts that the association may issue, and in this sense, I invite the tribunal to follow me to page 33, so to address the binding nature of those legal acts. The legal acts that the association may provide, one of them is on clause 3, which provides, and I quote, "A directive shall be binding as to the result to be achieved upon each member state to which it is addressed, but shall leave to the national authorities the choice of form and methods," end of quote. So it is not a general international obligation to comply with, Madam Arbitrator, but rather on the founding charter, the member states, they all agreed and they all relinquished sovereignty in respect of complying necessarily with the binding aspect of the legal acts, and the binding aspect of a directive is the result to be achieved. And the result to be achieved was the phasing out of coal-fired power plants. Do you have a follow-up question, Madam Arbitrator?
Yes, I do. But Wendy, I noticed that you're unmuted. Did you? Okay. So if we were to accept that Laos could avoid liability simply by in some way ceding various powers to ASNEC, would that create a loophole which would allow sovereign countries to effectively avoid potential liability by seemingly carving out particular powers, particular areas, and ceding them to other countries or organizations? And I emphasize the word seemingly, because then would tribunals and in fact would the international plane be in a difficult state in order to determine what powers have been ceded or have not?
I see, Madam Arbitrator, and indeed it would not create this legal loophole, as effective the rule on the attribution of conduct as between the member states and the organization is quite clear in respect of the implementation of these directives. It is not necessary that when member states implement legal acts, that by means of this transfer of competence, that immediately ASNEC would be responsible for all measures taken. So it is not an unconditional transfer of power so as to use the ASNEC veil for the respondent to not have any international obligation. Rather, what Article 120 of this founding charter clarifies, by means of referring to Articles 6 and 7 of REIO, the Articles on the Responsibility of International Organization, Article 7 of REIO clarifies that the international organization will be responsible only if it exercises effective control over the measure. The tribunal must then interpret what constitutes effective control. And in this sense, the draft of the International Law Commission referred to the understanding of the ECHR, the European Court of Human Rights, in the Berami versus France and Berami versus Saramati and Saramati versus France, Germany and Norway, in which the ECHR understood that effective control is when the international organization, and I quote, retains the ultimate authority and control so that operational command only was delegated, end of quote. Thus, what matters is to see who has the control over the specific measure to be questioned. And the specific measure with respect to Law 66/2016 is the phasing out of coal-fired power plants. This is binding. The claimant could have questioned the form and method as it appears to do so under these proceedings, and the form and method is something that the member states can be held liable for. For this is not within the effective control of the organization, only the result to be achieved, the phasing out of coal-fired power plants. Have I answered your question, Madam Arbitrator?
Mr. Martins, could I ask a follow-up question as to form and method, please? And you may be coming to it, and if you are, please deal with it in the ordinary course of your submission. What, if anything, do you have to say in response to the claimant's point that the biomass substitution power plants for the coal in claimant's submissions is as polluting, or more polluting, sorry, than coal-fired power plants?
Madam Arbitrator, in fact, we have the respondent has two submissions to make in light of your question. The first, in respect of form and method, is that the alternative which was given by ASNEC was for the member states to gradually reduce before 31st December 2028 the operation of coal-fired power plants. Within this discretion, within the formal method, the respondent chose to give the maximum amount of time without gradually reducing until the deadline. And in this respect, it did not breach the fair and equitable treatment. Now, with respect to biomass, actually, quite to the contrary, authorities on renewable energies actually provide for the substitution of fossil fuels for biomass, and this is why biomass is included within the renewable sources that are provided incentives upon by Law 72/2016. So if the tribunal is to analyze what were the sources that were incentivized by means of Law 72/2016, it must address the fact that coal is publicly known to be the most pollutant of the fossil fuels and the one that is being phased out earliest by governments all around the world. One such example is China, whose energy framework is deeply reliant on coal, and it will phase out of coal power plants before any other fossil fuels. There are no plans to even phase out of thermonuclear that need gas or oil to be burned upon. And in this sense, Madam Arbitrator, if I have answered your question.
Yes, could you just clarify one point for me? Is the issue the polluting, as you both refer to, of one versus the other, or is the issue, the underlying objective here, in fact, to reduce net greenhouse gas emissions? Or do you see those two as being one and the same?
Madam Arbitrator, in fact, under the directive, they are one and the same. The member states must reduce CO2 emissions at large, and they must also completely phase out of coal-fired power plants. It is not only that, but Article 2 of this directive also provides that the member states, and this leads me to my second submission on the merits, that this directive provides that the member states shall increase the consumption of energy from renewable sources, and biomass is one such renewable source, to at least 75% by 2030. And due to this also obligation to increase the renewable sources to at least 75%, this is why Law 72, which was a viable alternative provided for by the respondent, it is why Law 72 is not discriminatory and does not go against the legitimate expectations, if any, of GNB. Addressing the discrimination first, members of the tribunal, it is clear that Law 72, and neither is Law 66, is discriminatory against GNB or even the original claimant, the investor. That is because, members of the tribunal, as a Mr. Arbitrator question, Madam Opposing Counsel, what happens is that all producers, operators, and owners of coal-fired power plants are being treated the same way. Coal-fired power plants will be phased out not only on LEOC, but on claimant's home country and every country in the ethnic region. Be those coal-fired power plants belonging to investors, protected or not protected, or if they are owned by domestic economic sources. And in this sense, members of the tribunal, this measure was not discriminatory, as the phasing out was to all plants in this sector. In this sense, the respondent should like to make reference to the award on the case of Saluka versus the Czech Republic, in which indeed the tribunal found that the Czech Republic acted in a discriminatory manner against the international investor. And I must present the context of the case so as to assess whether there exists discrimination or not. Under those circumstances, the state intervened in the 4 major banks of the country and also on the foreign investors bank. But the Czech Republic, after this intervention occurred, rescued only the 4 national banks, but not the international investor bank, with no means being provided as to why it did rescue the national banks and it did not rescue the international investor bank. With respect to the present case, all coal-fired power plants are being phased out, be it from international investors, be it from national, be it they belong to nationals of LEOC itself. The measure is thus not discriminatory, and with respect to the access to the energy grid, the case file actually points to the contrary of what's presented by the claimant. Claimant itself, in its notice of arbitration, has acknowledged, recognized, and conceded that Taicadia 1 is the only power source, the only coal-fired power plant within the municipality of Taicadia that traditionally relied on receiving energy from other municipalities in the country. It is not clear in any moment of the case or in the presentation that was given in this hearing how this preferential access to the energy grid that renewable sources have will affect the operation of the coal-fired power plant of the claimant in the municipality of Taicadia. Quite to the contrary, as this is precisely the only coal-fired power plant in the region, and that is the only source that provides energy for the municipality nowadays. There does exist as the claimant called, a nexus between the measure and the objective with respect to Law 72/2016 due to Article 2 of the ESNIC Directive. The objective was to increase to at least 75% the existence of energy renewables in the region, and Law 72 precisely tries to increase at least to 75%, while also providing viable means for owners of coal-fired power plants to convert their power plants into those that burn renewable sources. And the case file clarifies that the conversion of those coal-fired power plants was possible. Now, with respect to GMBs...
Just a brief question. Basically, the conversion is on the table, but the conversion would require substantive further investment. Isn't that correct? And the burden for that would be on the investors.
Indeed,
and the investors would have to also rely on, basically trust you that the environment, the regulatory environment will not change again.
Mr. Arbitrator, indeed, this investment would fall upon the shoulders of the investor, but it is an alternative which was given by the respondent and which was not even envisioned by the directive. And as the case file has not mentioned, no other countries in the region, for example, well, Falcon did not provide any possibility for a conversion. And Mr. Arbitrator, although the investment would be made by the investor, it is also true, and I see that my time is about to elapse. Can I request an additional 2 minutes just to answer your question? Thank you, Madam Chair. After the conversion is made, Mr. Arbitrator, the prices are substantially above current market prices. So the investment made in the conversion could be recaptured by the investor due to the margin of the price that will be paid by this newly converted.
But isn't it correct that an assessment of whether the investors would be able to recapture the original investment would be case sensitive? So if that is the case, then the question is, did the state perform an ad hoc analysis for each coal-fired power plant of whether or not the compensatory measure would allow to recapture the investment?
Indeed, it made, Mr. Arbitrator, a general assessment. If the
a general assessment or an ad hoc assessment for each plant? Because
as far as we are aware, Mr. Arbitrator, it was a general assessment, but even if a specific assessment is to be made, GNB specifically, and GNB speaks to GNB's legitimate expectations. GNB invested only 150 million to buy this $1 billion investment. And not only it could invest in converting the power plant, but also seeing the case at hand, every coal-fired power plant that is converted will receive a premium upon the price, and thus this investor could use the premium so to repay the investment.
Okay, let's pause for a moment here. So is it your case that basically the only legitimate expectations that GNB could have in this case are related to the investment that it made when it bought the assigned claim?
Mr. Arbitrator, if GNB is referring to expectations that it had after the assignment, because before the assignment it was
I'm just asking a purely general question on the basis of the framework of the case. So is it your case? Is it your legal argument that the only legitimate expectation that the claimant could have in this case is the expectation that has to be somehow related to the assignment? So that should exist basically when the assignment agreement was made. It could not deal with the legitimate expectations that MFNB had at the time when it made the investment. So in other words, it could not claim for legitimate expectations that MFNB had.
Madam Arbitrator, I see that my additional 2 minutes have elapsed. Can I answer the question with respect to the legitimate expectations and then quickly address that they do not exist? 2 minutes? You are on mute, Madam Chair.
I answer the question, and I will ask our co-arbitrators to permit you to answer and wind up, because we are running out of time. Thank you very much, Mr. Martins.
Perfect. Mr. Arbitrator, if the tribunal indeed accepts the validity of the assignment and the assignment of the claim specifically, then the claimant may address legitimate expectations that pertain to the original investor, though that is the expectations back on 2010. And then quickly, also addressing your question, Mr. Arbitrator, there were no such legitimate expectations because the claimant relies only on a political statement made by the governor, in which the word that was used was for cooperation. And it does not fall within the regular purview of a regional governor, neither to promise or to dictate the energy policy at large of the nation of Laos. And in this respect, members of the tribunal, if there are no further questions, I reinstate my submissions that the measure Law 66 at least is attributable to ASNAC and not Respondent, and neither Law 66 nor Law 72, they infringe the fair and equitable treatment standard, and they are not discriminatory against the investor. Thank you.
Thank you very much, Mr. Martins. Ms. Quintero de Videlia.
Yes, can you hear me well?
Yes, thank you.
Members of the tribunal, GNB set out the factual background of its claim in its notice of arbitration, in particular in paragraph 17. Then, under Article 21 of the UNCITRAL rules, GNB is allowed to formulate its claim without any restrictions in its statement of claim, which Claimant did in pages 27 to 37. And Claimant decided to ground its case on Law 72, which is the measure causing present damage to GNB as a creditor. Yet, opposing counsel acknowledged, and I quote, "LAOC was responsible for implementing Law 72, end of quote. By doing so, Respondent is acknowledging that the two conditions for international responsibility to be met are met. That is, first, that Law 72 is attributable to LAOC, and second, that Law 72 breaches LAOC's obligations under the treaty. This is why, by following Respondent's own assertion, this tribunal should have LAOC responsible for GNB's present damage."
Counsel, can I, if I may, Madam Chair, ask a follow-up question? So, is it correct that basically a good portion of your claim on the merits rests on the second para of Article 2.1, whereas prayers for relief, just in order to, so we would pin down your prayers for relief correctly, prayers for relief says that you ask this tribunal to declare that the Respondent treated the investment unfairly and inequitably, and thereby breached Article 2 of the treaty. So basically, the prayers for relief is put in a bit of a narrow way and focusing only on fair and equitable treatment and not on the second para of Article 2.1. Or still, the claim for discrimination that I think, if we understood you correctly, that you are presenting is somehow captured by this formulation.
Right, I think I had the same question. Is your case primarily fair and equitable treatment or discrimination?
Members of the tribunal, Article 2 of the treaty, which refers to the treatment of investments, covers both the fair and equitable treatment and impairment by unreasonable and undiscriminatory measures. This is why GNB's claim rests on Article 2.1 of the treaty and covers both grounds.
Thank you very much. Arbitrator Tan, did you have any further questions? No. Okay, thank you very much. All right, Mr. Martins, thank you.
Madam Arbitrator, should I proceed with my rebuttal?
Yes, please.
Thank you. Members of the Arbitral Tribunal, even if the Tribunal is to accept the new grounds for claimant submissions, it is true that Article 7 of the ASNEC Treaty already provided that the states should strive to improve their environmental laws, but also the very ASNEC founding charter on its Article 61.2 provided for a collective aim for a high level of protection of the environment that would be, and I quote, based on the precautionary principle and on the principles that preventive action should be taken. Not only that, members of the tribunal, but also the claimant has relied specifically on political representations that do not specify. There is no specific representations, and the very case law which was brought by the claimant, that is El Paso, recognized that a general political representation made by the state of Argentina was not binding. Thank you.
And what is the source? Is there a specific source for your precautionary principle, or are you relying on customary international law? Is there a specific source in the treaties?
Yes, Madam Arbitrator, the precautionary principle is on Article 61.2 of the ASNEC founding charter.
Okay, and what about the ASNEC treaty? Anything in there?
The ASNEC Energy Treaty, Madam Arbitrator, in fact, it is within the same framework as the ASNEC Charter. The ASNEC Charter and the ASNEC Treaty, they were both acceded and signed by the countries on 2012, and other than the ASNEC founding charter, that is Article 7, that Madam Chair questioned the claimant, and claimant did not address the fact that ASNEC Energy Treaty, Article 7, provides for the states striving to improve their environmental laws.
Right, my question, Mr. Martins, was more addressed on this occasion to Article 9.1a.
Yes, Madam Arbitrator, 9.1a, with respect to the necessity to protect human, animal, or plant life, would be a defense that the respondent could allege, particularly against Law 66/2016, that phased out of coal-fired power plants, because those plants were proven by scientific researchers that they have a direct correlation with the disastrous floods that were happening in the country. But with regards to Law 72, specifically, that claimant appears to be challenging in these proceedings, Law 72 is the respondent striving to continue to improve the environmental laws while also complying with Article 2 of the ASNEC directive, which provides that the member states should have at least 75% of their energy framework based on renewables by 2030.
Thank you very much, Mr. Martins.
Thank you, Madam Chair.
Arbitrator Tan, Arbitrator Kondrashov, any further questions for Mr. Martins? Okay, now just to check with the arbitral secretaries, there are no further rebuttals, sir rebuttals. We are at an end.
It's time to start drafting the award.
Excellent. The job starts as it were.
Yes, we'll congratulate all of you. Thank you very much, Wendy, Charis, and Nikita, Council. It was certainly a pleasure listening in. I'm going to end the live stream now. I'm going to remind viewers that shortly we'll be starting a briefing on the reform of investor-state arbitration and our awards ceremony. And Arbitrators Council, please stay here for a moment.